Welcome. We are here with another one of our discussions with our moderators in anticipation of the Qui Tam conference, which is in Washington on February 27th and 28th of 2020. We are here with Selina Coleman. Selina, you are a partner at Reed Smith. Tell us just maybe a little bit about your panel.
So we are presenting on the False Claims Act and discovery in the wake of the Supreme Court's decision in Escobar.
So tell us a little bit about Escobar. I mean, it kind of has a little something for everyone, both for the relators bar and for the defense bar. Talk to us about materiality in particular and how that plays out in discovery that maybe might come up in your panel.
Absolutely. Escobar, to your point, was perceived as a win by both the relators bar and the defense bar. But one thing that really came out of it is that when the government has knowingly paid a claim, that is strong evidence that that matter is not something that's material to the government. And as a result, after Escobar, both the defense bar and the relators bar really want to have a sense of what did the government think about certain conduct and whether or not that conduct would have mattered to them when they paid certain reimbursement claims.
So why is then discovery relevant in that situation?
So the discovery from the government could actually go to show what the government was thinking when it might have paid certain claims. And there might be some things that the government might not have contemplated whether it mattered or not to their payment decision, but to the extent that the government did review something, did discuss internally, whether with respect to certain defendants or just generally discussed a certain type of reimbursement claim or a type of conduct, for example, in the context of reviewing a Qui Tam lawsuit, that might become something that would matter both for defendants and the relators in that case.
Does it matter how the government has treated other defendants at all, or just the one defendant that's seeking the discovery?
It could matter how they perceive the issue for other defendants. If the government has looked at something and decided that it isn't something that would necessarily affect their payment decision and decided to keep paying the claims for other defendants, then the defendant in the relevant Qui Tam lawsuit might say that that would show that it wouldn't be material to the government in that context as well.
So last year we had Michael Granston speak at the Qui Tam conference, and one of the things that he stressed was the fact that the government was not going to be goaded into dismissing claims merely because discovery was a nuisance for a particular agency. Comment on that. How have you seen that play out?
I certainly agree with that sentiment. While Escobar has led to increased discovery requests, which are known as TUI requests, that isn't something that should be used, at least from my perspective, as a tool to wield against the government. It really should be something that's used by the defense bar or the relators bar to try to get the evidence it needs to either prove relators' case or, in the case of defendants, to show that relators' claims cannot survive.
So one of the things we try to do at the Qui Tam conference is have viewpoints from really all sides. Tell us a little bit about that. There'll be relators counsel, government counsel on your panel. Who should we expect?
Absolutely. We wanted to present a balanced panel and recognizing that many of our audience members will want to see what the government's perspective is on seeking discovery from their agencies. We do have two folks from the government. We will have Lieutenant Colonel Chris LaCour, who is the head of torts for the Army. We'll also have Amy Cossack, who's with the Department of Justice, and she's a trial attorney. So we will have both of them represented on the panel. They've dealt with a number of TUI requests. We'll also have Chris Harwood. He is a partner at Morvillo, and he will provide the defense perspective. We will also have Jed Wolfcutt, who is a partner at Stein Mitchell, and he will speak on behalf of Relators Council.
So I want to finish with maybe just a little bit about you. Lawyers are people too. I mean, other than faith and family, give me a sense of kind of what gets you up in the morning. What's your passion?
My clients, really. I have always loved healthcare. Since I was a child, it's always been a passion of mine, but I was an English major, so medicine was in the cards, so I am so excited about what they do. They are doing great things, and it is my pleasure to serve them and work with them to solve problems.
Selina, thank you. We look forward to seeing all of you at next year's Qui Tam conference. It is on February 27th and 28th here in Washington. You can register at the Federal Bar Association website at fedbar.org.